We've come across quite often a scenario where the clients are the investors in a joint venture property development. They enter into this joint venture with an experienced property developer who was going to drive the project and develop it accordingly. And usually when the client comes to see us, the problem is the clients don't know what's going on with the project, or sometimes the project is already going badly and they don't know what they can do to keep the loss and control the risks. One of the challenges is how do the clients get access to the financial records of the company and know what's going on. When the clients come to see us, the first thing we do is to conduct searches in order to understand what has going on with the title and with the company itself. The second thing is by writing to the other side to have access to those financial records. If they refuse to provide those records, there are ways either through the court process or by putting pressure on the other side to get those documents. And one of the examples is to make an application through the court under Section 247A of the Corporations Act. Another challenge is what if the other side is in the process of disposing of the assets? And that can be quite serious because once the asset has been disposed of, even if you win the litigation, you might not be able to enforce the judgment. In a case that we've been involved, and in fact this hasn't happened more than one time, is we will apply to the court for an urgent freezing order in order to freeze the assets. It is not an easy application and it depends on the circumstances, but we have successfully obtained those freezing order in order to preserve the fruit of the litigation. One of the challenges is the client doesn't know what's going on and how do you access to the records of the company. So sometimes we can do searches in order to understand what's going on with the title and the company. And other times, we will be obliged to write to the other side to request financial records of the company. And if they refuse to provide these documents, in some circumstances, we can make an application to the court under Section 247A of the Corporations Act. Another challenge that we have come across is when the asset may be disposed of. And in that case, we can make an urgent application for freezing order. It is a complicated process, but we have successfully obtained freezing order on a number of occasions. I think we consider strategy in the early stage, and we understand timing is important. So once we understand the client's instructions and understand the circumstances, we do the searches as soon as possible, and we try to find the most cost-effective way. We think broadly about not the litigation itself, but whether there's any, for example, stamp duty implications, or if the client is a foreign resident, whether there's any FIRB issues we need to consider. We also understand that the timing is important, so we want to act quickly in the litigation matter so that we can deliver the most cost-effective results for the client.